Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Again, this week, as always, we've been highlighting candidates and specifically right now, paralegal venture candidates, getting to meet them and learn more about their platforms. As always, the views and opinions are of the candidates alone and don't reflect me, Justice and Pieces, Trios College, or any of the other education institutions or organizations I'm affiliated with. Today we have back, I guess we talked to Mike as part of the Good Governance Coalition when we first started this event. And now I think it's time to kind of get to know Mike a little bit more. So Mike, thanks again for joining us. And perhaps you could tell us a little bit more about yourself.
Hi, JP. First off, thanks for having me back again. Thanks for doing this series. I think it's very educational for not only the voters, but also for the students that you've got. I know that when I went to Trios, I did not really know the governance model, or wasn't taught the governance model of the Law Society. We just taught the regulatory function and what we had to do, our fulfillment. So I think it's great because I think there's a real need for this type of education. I see amongst many of my fellow paralegals and also even some of the candidates don't really have a firm grasp on what the role of a bencher is. It seems like a lot of the proposals we've seen put forward are things that are not within the purview of the Law Society, things that would perhaps be better done through an advocacy group. So, it's important to realize that the role of the bencher is to regulate and govern the Law Society in the interest of the public and not to be a paralegal advocacy group. So a little bit about myself. As I said, I went to Trios College. That's where I did my paralegal education. So, some of my views may reflect on Trios, I suppose, notwithstanding your disclaimer. But I finished in 2015. And after I became licensed, I opened my own practice. And then I worked with a couple of other paralegals for a couple of years doing primarily small claims and landlord-tenant work. And then in 2018, I had an opportunity to go in-house and work for the Municipal Property Assessment Corporation, better known as MPAC, where I do litigation, assessment litigation. So anybody that wants to appeal their property tax assessment, I represent MPAC at the ARB, and that's what I do now as a paralegal.
Perfect. So let's then look at why you're running and specifically why, or how kind of maybe it came about that you're running as part of the Good Governance Coalition.
Great. Well, I think that, now paralegals have been regulated since 2007. So that's 15 years. And I think we're at an important crossroads for the profession. I believe that, we've made some strides forward, the recent expansion of scope and family law, though maybe not everything we had all hoped for, but, it does make some important steps forward. And I think that right now we can either continue to go forward or, we could go backwards. And I just, some people had asked me to run, and I sort of had been mulling it over. And as I was thinking about it, I saw some of the other candidates coming forward, and I just thought that what we needed at Convocation was professionalism, respectful debate, and decorum. We didn't need, people coming in and being the bull in the china shop. Certainly, going back to the role of the bencher, you're one of 53 people. So you alone can't get anything done. You have to be able to work with other people. And that was one of the reasons that when I was approached by the Good Governance Coalition, they asked me to be a paralegal candidate. And I agreed after looking at what they stood for. And one of the things that really stood out of all the things that the Good Governance Coalition stood for, one of the most important things to me was that all of the 40 lawyer candidates that are part of the Good Governance Coalition have signed a pledge that paralegal services are critical and that paralegals are critical to access to justice and the justice system in Ontario. And I thought that as we're trying to, bring some of paralegal issues forward, it's important that I'm already working with a group that acknowledges the importance of paralegals and their role in the justice system.
Now that kind of brings to the whole coalition topic there of slates and now certainly not I think the Full Stop group doesn't have anyone explicitly that's running for the paralegal venture candidates. So I mean, they may be supporting someone, or I'm not sure exactly the verbiage there, but on the lawyer side, it's very clear cut, right, that you have 40 good governance coalition members running, I think 35 of the Full Stop group. And essentially there's kind of this, it seems kind of hypocritical, right, that, hey, they're the stop group, that 22 of them from before, they were the problem with, how the law studies functioned in the last 4 years. So we're going to create our own slate, but slates are not something that we want. So when we're elected, we're going to do away with them. And you've seen all sorts of kind of posts, kind of what's going on here. So Mike, you're first of the paralegal candidates I'm talking to about this. How does that kind of make sense?
Sure. Well, the irony is not lost on me that we are a slate or a coalition running, and one of our pledges is to look at the slate. So I don't think I think it's a little bit of a mischaracterization to say that we're a slate that's going to run and then not allow slates to run after. I believe what we're going to do is look at the evidence and make evidence-based decisions and see what is best for the best interest of the public. From my, when I, having been involved in the previous election, just as a voter and actually organized an all candidates meeting in London, Ontario. So I'd had some knowledge of what the Full Stop slate was all about, and I believe that the last time there were more votes cast for non-slate candidates, but just because of the vote splitting and distribution, the slate candidates got elected. So I think that was the idea to put together a slate of people that are like-minded, that share the same core values. Was brought about in order to sort of stop that vote splitting. So we're even now we're asking, and I look at when I look at the list of candidates, there's no slate option. Everybody has to earn the vote of the voters. So I can't sort of ride the coattails of my fellow candidates. I have to get out there and tell people what I'm all about and why I think they should vote for me. Having said that, looking at the list of paralegal candidates, certainly my four people that I have on my team, I think are by far the best candidates that are out there. So whenever I'm asking for support for myself, I'm also talking about my other fellow candidates and asking for support for them. So once we get to convocation, if we're all elected, we've pledged to look at the issue of how the elections are conducted and what is in the best interests of the profession and the public. And, whether that's to let things continue as is, or whether it's to put rules in place. I believe one of the questions that's come up more on the lawyer side than on the paralegal side is who is funding the coalition, and I can tell you, who's funding it is the profession. It's people who we've all put in, we've all made donations and pooled our resources, as it were. But right now, as far as I know, there's no rules. The Law Society has no rules. Like, if you run in a municipal, a provincial, a federal election, there are rules about who can donate and is there maximum donations, things like that. And right now, those are things that the Law Society rules are silent on, and it's perhaps something that should be looked at and looked looked at closely because it's important. We're electing the Board of Governors, the convocation, and it's 53 people. Well, 45 people elected that will will make some important decisions over the next 4 years, and it's important to know where their funding is and what the rules are around elections, and have some better rules in place.
Yeah, because it's interesting. I mean, and certainly I'll have the opportunity to talk to some of the full stop group on the lawyer side, is there anything really wrong with this? And I'm a little surprised because I know even there's I don't know if it's still the case, but I saw there was an event planned in a couple of weeks where they didn't want any candidates who are not independent. And I'm like, well, hang on, right? I mean, is this, saying, hey, is this any different than saying, hey, my buddy JP's running, vote for both of us, right? I remember, running for student government, many years ago at Osgoode, where it was kind of like, hey, we're in the same section, vote for both of us. But it doesn't necessarily mean anything more than that. Like, we're not going to do everything exactly the same. And even with the stop group, right? I mean, once that statement of principles was addressed, I mean, then they were free in theory to do what they wanted in terms of voting. So I mean, is that just sort of maybe effective way of pooling resources, as you put it? Or I mean, again, something that you mentioned that you might be looking at is this kind of unfairly hurt some of the other candidates who may be running independently?
I don't know if it's unfairly hurt. I was only when I became involved in this election, and talking to past candidates, past ventures that aren't running this time, that I found out that they, in fact, worked together before, but it was less transparent and more behind the scenes. And whether they pooled resources or asked for support together, things like that. This time we're upfront. Everybody knows we're running together. We're sharing resources, but we each of the candidates and specifically, I can say I'm more familiar with the paralegal candidates. That specifically, we each have our own individual things that we want to accomplish. We share core values, but we if elected, we would all vote. We're not pledging to vote as a block. We're going to vote individually. Everybody brings their own perspective. We have a diverse group, either by practice area. We all practice in different areas. We have an educator, Paula Callahan. We have Michelle Lamazo, who works in WSIB. We have Deborah Mora, who's been involved with EDI issues, and Dimitra, who is an in-house paralegal for a large business. Myself, I work for sort of a government organization. So we all have a wide range. I kind of joke with my candidates, I'm the token male on the group, but we all bring different perspectives, and we all have our own ideas, on different things. So we would all vote individually, not as a block. We're just, truly, I think there's been too much made of it by some people. We're certainly not, I've seen some overblown rhetoric, quite frankly, about how, this is groupthink, and this is can lead to, everything from, I've even heard, things like communism and totalitarianism and things like that. And it's just, quite frankly, ridiculous. Like I said, we share common core principles, but we all bring a different perspective, and we would be, 5 individuals at convocation. The fact that we share the core values, just might make it a little easier to work together. We might, that sort of thing. If somebody's diametrically opposed to you in what they believe in, it might be a little bit more difficult to work together. So, like I said, I think it's a bit of a head start that we're building relationships already. Like I said, we're one of 53 people on convocation, so you have to work together. That's part and parcel of the job. You have to convince the rightness of your position, whether it be with the other lawyer benchers or with the 8 lay benchers. You have to convince them that what you're advocating for is in the best interest of the public. And I think this is just the start of that. Really, it's like we're building these relationships even before the election, and I think it can only be beneficial to the profession and to the public.
Now, within that framework, then you mentioned, there's this sort of shared ideals and vision, but within that, you have your own sort of priorities there. So maybe, Mike, you tell me about what are the one things or the few things that, you think are really important in this election. And if you're elected, that you will try to push forward at Convocation.
Yeah, absolutely. I think that one of the big things is that we, whether we like it or not, that the 5 benchers that we elect are sort of the face of the profession, even though, we're not, our job as benchers is to govern in the public interest, not to be the advocacy group for paralegals. However, those 5 benchers are in essence the face of the profession. So I think it's important that we bring respectful dialogue, we bring decorum and professionalism to Convocation. And I think that, again, that I would do that. I certainly have done that in the past, working on other boards. Specifically for what I would advocate for and champion if I was elected, I would promote the expansion of the paralegal scope of practice to further access to justice, whether that be in further expanding the scope that we've gotten in family law, or dealing with the immigration issue, or other areas, expanding the right now paralegals can do POA appeals, but no other appeals. So that would be something that we could look at, like further appeals and what that looks like in terms of on files that we've advocated on in whether it be at the landlord tenant board, at the assessment review board, at various other tribunals, and so on. That's one thing. One of the other things that I think now that we've been licensed and regulated for 15 years, I think it's time that the exemptions to licensing in bylaw 4 be updated and eliminated. I know that they've been, over time, have been slowly whittled down, but I think we're at the point where it's in the interest of the public that they receive competent representation, whether it be at tribunals. Sometimes you have landlord tenant matters where the dollar values that you're talking about are quite large, or the assessment review board where I work, you're dealing with properties that are very valuable in Ontario. Real estate has kind of gone through the roof. So we're dealing with it should be high time that only licensees be allowed to provide representation. And I think that would eliminate a lot of the people who have a lot of friends and might be showing up at tribunals or at provincial offences court, I think, representing a friend. So it's or property managers, realtors, things like that. So I really think it's time that we eliminate the exemptions in bylaw 4. I also would advocate for a more equitable number of paralegal benchers. I honestly don't know where the number 5 came from and why that's the magic number. I know there's people look at there's 8 lay benchers. Why? I would think that paralegals should at least have the same number of benchers as lay benchers, but I think it would be a time to look at the number of lawyer benchers versus paralegal benchers versus lay benchers, and have more adequate representation of the paralegal perspective on Convocation, because we deal with a lot of vulnerable people. A lot of our clients are members of the public that are in a vulnerable situation, and we should bring that perspective forward. One of the other things, when I've listened to some of the other interviews that have come on, that have been on your series earlier, and it seems like there's this adversarial relationship. The lawyers are the enemy on the other side, and I think that that's not the way we should approach things. I think that I would promote not just at convocation, but in the profession, promote more collaboration between lawyers and paralegals. When I was in private practice, I had, oftentimes I have lawyers refer matters to me, and they recognize that, paralegals sort of do some areas of law that not a lot of lawyers practice in, and that we're good at it. And so, instead of looking at each other, lawyers and paralegals, as competition, we should be looking at how we can collaboratively provide legal services to the public and that are best for the public. I know at my work with MPAC, when I started 5 years ago, there was about 60% of the appeals that MPAC did went to external legal counsel, and those were all lawyers. And when over the last 5 years that MPAC has really promoted the paralegals and hired many of them, and now so to the point where all those appeals have come in-house and are being done for the most part by paralegals, with only like 10% of appeals now done by external legal counsel. So I think, again, there's many different ways we can collaborate with lawyers to both advance the profession and also to better serve the public. So and lastly, I think one of the other things there's just recently, I guess through the course of the selection, there's been a report came out by the Paralegal Standing Committee and updated some of the educational components, or will be updating some of them. And I think that I read that report and actually was quite pleased with a lot of it. And I believe that we should be promoting more hands-on training for paralegals as part of their education. Doing more things. So I would advocate for that. 120 hours goes by really fast, and a lot of times you're just kind of getting your bearings, and you don't get to do substantive work and get that experience that you need because when you're first starting out. So I would definitely promote that. And then lastly, I think one of the major things is fiscal responsibility and transparency at the Law Society. Our fees, we pay, I wouldn't say large, but we pay a substantial amount of money in fees. And I think it's incumbent on the benchers to ensure that, things are done in a fiscally responsible and efficient manner, and just we'd have to find ways we can save money, and where we can do that, we can reduce our fees. So those are the things that I would, those are sort of the items that I would really advocate for and champion if I was elected as a paralegal bencher.
Great, thanks, Mike. So a lot to unpack there. So I'll try to go over in the next half an hour or so, kind of a few of those points there, separate them out. But again, kind of going back to what you were saying about, hey, we have these 40 lawyer candidates. Now, again, we can't predict the future. We don't know who's getting elected from the paralegal side or the lawyer side, but there's a realistic possibility, let's say, that there may be a number of members of the coalition on the lawyer side, along with your group of paralegal bencher candidates, that can get elected. And you touched on it a couple times there with, sometimes it creates this us versus them mentality of or paralegal. I can't even say us because I'm a lawyer. So paralegals versus lawyer mentality, and sometimes I think it's as you point out, it's unfair, right? That is that criticism there. Maybe there are lawyers that have this sort of protectionism of their turf, so to speak, and maybe that's part of the reason why the family law turned out to be it. But do you think that bodes a better chance for you to look at issues like expansion of scope when the possibility is very real that the people that you've been working with and going to bat for each other are going to be the people that you may collaborate with at convocation, right? And it's maybe an easier sell because, ultimately, as you point out, you need 27 votes, right? And even if all the paralegal benchers were all steadfast, and even if they got all 8 of the lay benchers, there's still another 11 votes to go. Oh, sorry, another 14 votes to go, right? So
Yeah.
what do you think about all of that with that in the background?
Yeah. Well, absolutely. I think that you're absolutely correct. You're kind of, well, going back a bit. You're kind of a thus. You're neither them or us. You're kind of you're a lawyer, but you teach paralegals. So, but anyway, I think that what we, I think it's again, we've started to the 5 paralegals on the Good Governance Coalition have each started to build relationships with those lawyers, and I don't know what if I had a crystal ball, I'd buy lottery tickets instead of running for venture. But I don't know what's going to happen. We don't know who's going to get elected, and I think that we need but I think that we're already starting to build those relationships and work together. And I think that the lawyer candidates have already acknowledged that paralegal services are critical to access to justice. And I think a lot of times we hang that label on things, and just because we're paralegals, it doesn't mean that we need to ensure that it's in the best interest of the public to expand the scope, and into what areas is best to expand the scope if we decide to go that way. But I do think that working together with this prior to convocation with a group of lawyers who, again, already acknowledge the important role of paralegals, and I think that really, is a good example of being able to, move developing the skills that you need at convocation and being able to move things forward in a thoughtful manner. So, I believe that's working collaboratively with those group of lawyers has already started.
And I guess kind of related to that is you brought up, well, are these issues for the benchers to be doing, or are these issues for advocacy groups? And again, as much as I do teach paralegal students, I'm not very familiar with maybe what's happening behind the scenes or sort of deep into some of the associations and groups of paralegals. But I mean, is this something where you have obviously 19 candidates coming forward, 5 of you are going to get elected, 14 of you are not, but that some of that advocacy can continue, whether it's individually, right? I mean, there's certainly court challenges, there's, the Ontario Paralegal Association. Is that kind of better framed for looking at some of these things, or regardless, now, even if it's not yourself, for example, getting elected, that the benchers should be the ones kind of pushing some of this forward, or is it a kind of a combination of things like that?
Well, I think it's there's again, I think it's hard to separate the role. I think a lot of people have a hard time, but as a bencher, you have a responsibility to govern in the best interest of the public, not the profession. So I guess with that duty in mind, even if there was a proposal that came forward that was detrimental to not just to paralegals but to lawyers or whatever, if that was in the best interest of the public, you would have a duty to push that forward. So that's why I think that we as paralegals, we need strong advocacy groups outside of the bencher, because it's really not the role of the bencher to push forward a lot of the ideas that are being put forward. They're just not within the purvey of the Law Society. One of the things I saw one of the interviews, the candidate was proposing that paralegals decouple from the Law Society and have their own regulator. Well, that just, when you're a bencher, you can't push that forward. That's something that that's something for the provincial government to decide, not for the Law Society. It's something, if that was what you really believed in, you should be working with, whether it's the Ontario Paralegal Association, the OPA, or whether it's the Federation of Ontario Paralegals, or or even just going to the government through other groups. That's something that you would have to do in that role, in an advocacy role, not in a regulatory role. I've seen, people propose. I've seen other candidates propose or talk about legal aid, and that paralegals should be allowed to accept legal aid. And I fully agree with that. But again, that's not something that the Law Society doesn't run legal aid. It's not something that as a bencher, you would be able to wouldn't even be able to vote on it, much less put it forward. It's something that has to be decided by the government of Ontario and the legal aids of Ontario. I've seen other candidates propose, that legal every educational institution should have legal clinics that run in conjunction with it to give paralegal students hands-on experience. Again, a great idea. I think that everybody, but again, not within the purview of the Law Society. It's not something that the Law Society, unless short of mandating that every educational institution has to have a clinic, but I don't think that's feasible. So again, these are all great ideas that people are putting forward, but they're putting them forward in the wrong venue. Right, these are all advocacy things that should be that are better done by groups that don't have that conflict of interest with regulating in the interests of the public.
Yeah, because I think it's interesting as well, obviously, that in the interest of the public, right? And we keep hearing, that's the Law Society's mandate, and accusations certainly of, are the lawyers. The lawyer benches, are they operating in the lawyer's interests or the public interests? Or would paralegals be doing the same thing if we're kind of creating this sort of sandbox fight? And I've heard obviously candidates that say that doesn't even exist, right? That this is largely kind of sort of rhetoric to create this push for self-regulation or there's restrictions. I mean, I don't know, and perhaps talking to some of the current benchers and that I have before, or maybe again know a little bit of, well, have there been efforts to bring something to the floor of immigration or outside of the family law discussion? But do we actually have evidence that the lawyer benchers are voting down all of these proposals? Or are we also looking at, the question that I've posed to a few candidates is, well, how do you explain, or how can you explain a push for added scope without addressing if the competencies are in place? Right now, there's all sorts of value of whether going to university and then going to law school and articling and writing a licensing exam with all these different areas, if that really is much different than sort of the streams that are in place for paralegals, where essentially you're competent, you're doing MPAC work. Right. Tomorrow, you might be given a lucrative job offer to go and do small claims. And I don't know, you may have done it, but let's say you haven't, you can do that. Right. And again, within the purview of being competent. Right. And is that any different if instead of it being small claims, it's immigration? Right. But again, it all gets back to getting the 27 people to support that. And if you're looking in the public interest, there's a question of, hey, wait a second, if we just sort of wave the wand and say you can do all these other things now, how is the public interest still protected? So maybe you can talk a little bit more of kind of what may need to be done to further that in order to get the support, even if they are members of the Good Governance Coalition that are lawyer bencher. What do you suppose should happen?
Yeah, well, I think that if we're talking about we're talking about access to justice, but it's not access to justice unless it's competent access to justice. Just like consent is only consent if it's informed consent. It's the same thing in my mind. It's like we can just, I think a lot of people like to hang that label of access to justice on paralegal services and kind of think it gives it a free pass. And really, again, we need to ensure that the services that as licensed professionals we're providing are competent. And we have a duty, obviously, that right now, when you get your P1 license, you can do like you said you can run the gamut from provincial offenses to small claims to tribunal work, which are completely, they're all, they have some similarities, but also a lot of differences. So we have to be competent. That as part of our rules, we can only take on matters if we are either competent or can become competent in a relatively short period of time without added expense or delay to the client. So I think that as we're moving forward, and this is one of the things that I really when I saw the latest report from the Paralegal Standing Committee, and trying to start the revamp of the way paralegals are educated. I don't know what the program when I was in school we did it was a 1-year program, and that included our 4 weeks of field placement, and it was basically we did a lot of subjects in 2-week increments, and kind of scratch the scratch on the surface. I think that similar to when we're comparing lawyers and paralegals, I think I have a bit of a unique perspective. I just had last summer I had 2 kids that were called to the bar, so I watched firsthand what their education entailed, and I was able to compare it to paralegal education. And I noticed that in law school, they had in first year, they sort of had no choice of what they could do. They had sort of 5 foundational courses that they all had to take, and that built the foundation to what they were going to do further on in their latter years of school, and then in their practices. So I think that what we should do with paralegal education is do something similar and have foundational courses that are like torts and contracts and legal research and legal writing and advocacy and things like and evidence. And then once you have those things down pat, then you can take because those things apply regardless of where you are, whether you're in at a tribunal. You have to know how to advocate your position. You have to know what evidence is and what's the best evidence and how to present it. Or whether the same thing if you're in if you're in a provincial offenses matter, all those same things apply. Maybe different rules about forms and things like that, but those principles of evidence and advocacy and legal research and legal writing all apply. And then so that we could, if we had that base of skills, and then we were talking about expanding scope, then it's less of a question of competency because it might be some a shorter time to become competent in what forms need to be filled out, what how they're filed, what the timelines are, things like that. Those are things that are relatively easy to pick up if you've got those basic skills of advocacy, right? Legal research, legal writing, evidence, and so on. So I think then that would apply to family law. That would apply if we were talking about immigration. That would apply if we were talking about any further scope expansion, like being able to do appeals in divisional court or something like that. So I think that's where the basis of it starts, is becoming, getting ensuring that paralegals are competent in a base foundation of legal areas, and then they can take those and apply them to whatever area the scope would expand to.
Yeah, I think most, I know, or perhaps even all the programs kind of have a set schedule, right? I mean, maybe there's different sections or different campus locations, but by the end, typically everyone within the core program are finishing these 20 or so courses, and maybe the order is a little bit different, but or how they're arranged, whether it's like a semester or very similar to what you have. It's still relatively the same, except like maybe you had 1 course at a time. Now we have 2 courses at a time, but yes, I mean, I certainly agree that things like a practical approach. You've mentioned, another candidate has also mentioned about legal aid clinics, but again, that might be a question of, well, what can the Law Society, Paralegal Standing Committee do other than say, we're encouraging firms to take on students. I mean, or mandating even, once every 3 years you should have a student as someone that you're interning. I mean, outside of that, I don't know what more the Law Society can do. I mean, we can reach out to clinics. I can, as a paralegal program coordinator, can reach out. I'm on a board of directors of a clinic. That happens to also be with others. There's a hub there for Durham College students, for example, that we could be looking at those things, but that's something, again, within maybe a school framework rather than the Law Society sort of framework, right? And that sort of speaks to another point, right? Is that there's a lot of paralegals, newly licensed, or perhaps they've been licensed for a few years, that are leaving the profession or not even entering the profession, right? I know last week a number of my students wrote their licensing exams. They're all playing the waiting game now for the next 6 to 8 weeks. And I saw as well on LinkedIn the other day, or maybe it was even today, they got their actual license from the Law Society. So now they can hang up their shingle and start practicing. And there's a lot that are not making that transition, and we don't really know what those reasons are, right? And is it as simple as, well, if there's more scope, then there's more opportunities to make money in the profession and stay in the profession? Or is there something more that's missing that's leading to these numbers being very low?
I think, the numbers are low. They're in terms of, the number of licensed paralegals, the number of actually practicing is, is somewhere, I'd say about 30% or so. So somewhere in the neighborhood of 70% or 60% of licensed paralegals are not actively practicing. And you have to wonder, why that is. I think some of it, might fall upon the schools, in the sense that people may not get an accurate reflection of what life is out there. Once the function at schools are businesses. They want to put bums in the seats and fill up programs, and people may not be the vast majority of paralegals end up practicing on their own, and either as sole practitioners or small firms. And not everybody's cut out to do that. Because it requires you to be competent in the legal work. Then it requires you to be competent in or a good marketer. You have to get your name out there. A good networker, a good administrator. You have so many hats you have to wear, and not everybody wants to. Not everybody wants to do that. Not everybody has the skills to do that. I'm fortunate. I since I've gone working in house, I spend my day doing legal work. I don't have to worry about IT. I don't have to worry about marketing. I don't have to worry about collecting money. I don't have to worry about any of that stuff. So I know that I'm in a unique and privileged position. So I think one of the issues is in this, and why there's such a large drop off, is the lack of mentorship. I again, going back to the way I see it anyway, maybe perhaps I'm wrong, but I see that when lawyers finish law school, they article, and it's a longer, sort of 8 to 10 month term, and then they get hired on by a firm where they're a junior associate, and they can kind of get their feet wet. They can spend a few years learning about practice, and they're paid a salary, and then perhaps 5-6 years down the road they might go out on their own, or they might become a partner or something like that. Whereas like with paralegals, it seems to be that there aren't those types of there aren't paralegal firms. There's some, but really there aren't paralegal firms out there. It's most of the time it's sort of sink or swim. And I mean, believe me, I understand that. I did it myself. I had to I finished school and there weren't any jobs out there, so I had to make my own job. I started my own practice, and I had to try and go through all those struggles while trying to put food on the table and pay my mortgage. So I understand why I can really empathize with people that are out there and starting. It's not easy. And I think we need to make it easier, or otherwise, we're going to see, the profession fail. And I think part of that is, what the law, and again, like the questions, coming back to your questions, what can the Law Society do? We have like 3,800 approximately practicing paralegals. The Law Society can encourage those people to become mentors and to take, whether that's through, providing CPD hours for doing that, or maybe a reduction in fees for being, taking on a student, or, different things like that. Whatever the Law Society is within their scope, they should be encouraging and promoting that mentorship, so that when somebody comes out of school, that they can work with an experienced paralegal. I know when when I started at MPAC, I didn't know a lot about assessment law. I mean, I had worked in small claims and landlord tenant, so I had those skills of advocacy. I knew how to stand up in court or stand up at a tribunal. I knew how to do, case law research and things like that, but I didn't know the actual, ins and outs of assessment law. And one of the great things was I worked with a team, in the London office. When I started, there was, 3 experienced paralegals and one other person who started at the same time I did. And so, many times I could just kind of, turn around and say, hey, Bill, what's the answer to this? Here's my question. What's the answer to that? And he would tell me, and then I would know it for next time. And then, the next question would come up, and I turn around and hey, Tony, what's the question? So I'd had that mentorship there, and that really helped me come out. And then I brought my own certain, strengths to the role that I was able to help them with. So working together like that, I think that's something the Law Society can do, is encourage that mentorship. I know that there's the CAN program, but again, I don't know how many, what's the uptake in it. And I don't personally, I only know very few people that are mentors. So, I mean, we should be encouraging more people to do that. So again, whether it's through CPD hours, whether it's through credit on reduced fees, or some other incentive, but we really need to do that.
Yeah, I mean, and we've talked so much about MPAC, and I think that also brings up another point: is if everyone's going to do small claims, landlord tenant, or POA, I mean, before we look at maybe even expanding, right? I mean, not to say that that's not a possible solution as well, but is there a push towards, I know it's part of that same report, like, let's look at what are some ways to get people in those fields, right? I mean, certainly I can tell teaching tribunal law, when we come and learn about the assessment review board, well, now I know who I'm going to call, Mike. I'm going to hold you to it, that, hey, come and chat about what it's like to work, at MPAC, because there's not as many. I mean, former treasurer Teresa Donnelly would come and whatever school I happened to be at, she'd be like, you probably can do this presentation for me now because you've heard it so many times. But when we look at those statistics in one of the slides that she had, there's like a huge drop off once you get out of those big 3 to some of the other areas. And I mean, perhaps, maybe you can't have an entire practice in, one, tribunal, like, a smaller one, but it is possible. But some of the human rights, or WSIB, or the ARB, but is there maybe a something the Law Society can do more so than say, hey, try these other areas out, to get both the mentorship there, but to get newly licensed paralegals to kind of look at some other places to practice?
Well, absolutely. I mean, it comes, I think a lot of it comes down to the reason that people gravitate to those big, we call the big 3, is because that's where a lot of the business is. It's like where most of the files are. Also, it's where the public knows that paralegals practice in, and paralegals on. Now I was, I'm part of, because I did landlord tenant work in the past, I'm part of some landlord networking groups. And, now when landlords ask each other, for referrals, they don't ask for lawyers, they ask for paralegals, because they know that, and even now that you can go onto Zoom and you can watch hearings all the time. You can see that the vast majority of representatives are paralegals. So there's certainly in those areas, we need to become. So I think there was a few years back. I know the Law Society did have a bit of a campaign to promote paralegals. I know I used to live in a small town of Strathroy, Ontario, kind of sort of half an hour, 45 minutes outside of London, about 10 or 20,000 people. And there was a billboard, big old fashioned billboard in the center of town promoting paralegals, Law Society promoting paralegals. And so I think there's certainly awareness. The Law Society can raise awareness in the general public and as to what paralegals do and where they can represent. Like even in that campaign that I believe was 4 or 5 years ago, it was just paralegals were part of the Law Society. It didn't promote the fact that there's all these other areas that we could practice in, like human rights or criminal law or things like that. So I think when we, talking about the scope expansion question, obviously expanding scope brings more business, but also expanding within our existing scope is also very important. And I know it's something that Michelle Lamazzo has done. Actually, before I was a candidate, I did an interview with Michelle, part of a Law 360 series of paralegals at work in sort of smaller niche areas. And I know, like, again, I had a tribunal course, and I think we talked about the ARB for about an MPAC for about like maybe 5 minutes, and we just skipped right over it. And then and being a homeowner, I kind of knew what MPAC was about. So when I started, but I didn't know anything about assessment law, and I didn't know anything about the industry at all. When I started at MPAC, I was quite frankly shocked that the industry is dominated by paralegals. I'm routinely, most of the representatives of property owners are paralegals. Occasionally I'll get a lawyer for a large chain of a retail chain or commercial landlord or something like that. But for the most part, even on those files, like there's a certain retail chain that's government owned that is represented by paralegals. It's a huge industry. There's I think there's firms that I hadn't even heard about, and yet they might employ like 20, 30, 40 paralegals to represent property owners at the assessment review board. And I try and promote the area for people as much as I can. I know I've done a number of talks at CPDs and at colleges that letting students know about the ARB, letting them know about MPAC, letting them know about the other firms, and I think that's sort of things that we need to encourage and do more of. I know I heard a statistic just recently, speaking to former Treasurer Donnelly, that when the Law Society did a survey of areas where people practiced in, the number of people that practiced criminal law, the number of paralegals that practiced criminal law was an astounding 100. So out of 3,800 practicing paralegals and 10,000 plus licensed paralegals, that's like less than that's such a small percentage. It's not even on the charts. And why aren't more people practicing in that area? Whether it's lack of knowledge or lack of mentorship, or again, one of the other things is I think working collaboratively with lawyers to say that lawyers can represent on these charges. Why don't you hire a paralegal to work with you and that they can represent on these other charges and these other criminal law matters that that's where I think that it's really important. And one of the things that I would promote as a venture is the collaboration between lawyers and paralegals, and less of that antagonistic, like, them versus us, or, they're the enemy, they're the competition, or whatever it is. And I mean, I can understand why some of my other candidates, it might play well to create a boogeyman out there and to create the enemy as lawyers being the enemy, and they're holding us down. But I think you catch more flies with honey than with vinegar. So I think if we worked collaboratively together, we would be able to expand within our scope a lot more and have a lot more business without having to go through scope expansion, which, as we've seen with family law, is like a long and arduous process, right? It's like it was like 2014, I believe, or thereabouts, that the Boncalo report came out, and is only just in 2022 that the final FLSP was brought out, and the scope. So that took 7 years to come about, and certainly again was not what paralegals had hoped for. So in that we could expend those same energies getting people to practice within the scope that's there and underserviced right now. And there's so many areas. Like I could probably go on like another hour talking about just this topic alone. I know one of my former paralegal partners, Teresa Forrest, she does professional regulation. She's represented massage therapists, nurses, different things in professional regulatory proceedings. And that's something, again, that paralegals can do, but not a lot do. And it's a great area. And, if you've got the skills to do, other advocacy work, you've certainly got the skills to do that kind of work. And I think it's just that people don't realize that they can do it.
Now, Mike, last couple of questions here. I know you were, a student 7 or so years ago. I have students. One of my former students is here helping out, recently licensed, and wondering if you have any more words of wisdom for the students that are listening. Again, similar. I mean, we were talking quite a bit about getting into the profession, but any advice as they look to jump into the profession and grow?
Absolutely. I've actually found it quite enjoyable to go out and talk to classes. I've been to Fanshawe College here in London, talking about MPAC. I recently spoke to Georgian College via Zoom. One thing I would always encourage students to get out there and network. It's something that I wish I had learned long ago. I kind of go out there, get yourself, talk to go to events, go to call up people, have coffee with them, whatever. Have people that are get to know other or licensed paralegals that are already in the industry. And the other thing is with the networking is find an area of law that you really enjoy and and concentrate on. Don't try and be all things to all people. Don't take and I know it's hard, believe me, I know it's hard when you're starting out to you don't want to turn business away, but don't try and be all things to all people. Concentrate on whether it's one or two or three, sort of a small number of areas of law, and then you'll become good at them. You'll become better at them than if you're trying to do a little bit of everything. And you'll become known for those things, and then people will seek you out as opposed to you having to find clients. Clients will seek you out because of your knowledge and expertise in that area, and other professionals will also seek you out or refer to you. I mean, there's a paralegal here in London, Ontario. That's he's been around a while, like long before licensing. And I would say he has him and his wife are both paralegals. They work together, and they have a very small presence on the sort of a obligatory website. But I would say most of his business comes from referrals from other lawyers, because all he does is practice in small claims, and he's good at it. And he's known for it, and so he has clients coming through the door looking for him. So I would encourage people, students, especially when you're starting out, is find the niche area that you enjoy and that you like, and become good at it, and then build it, and they will come.
Perfect. So, Mike, thank you for taking the time again to speak with me now on your own. Last question here. Why should the paralegals that are listening to this, why should they vote for you, and in turn, the fellow candidates, the Good Governance Coalition candidates that you're running with?
Well, for me specifically, I've had experience being on a board of directors for a nonprofit organization in the past. I know what it's like to be one voice around the table. I know how to advocate for my position, and to work together with people and build a consensus and get things done. With myself and my fellow candidates, I think it's very important at this time in the life of the Law Society and in the paralegal profession that we bring professionalism, decorum, and respect to convocation. And I believe that the 5 best candidates are myself and my running mates to bring that to convocation and to move the profession forward.
Perfect. So once again, Mike, thanks so much for joining us. Thanks for everyone for tuning in. Take care, everyone.
You're welcome. Thanks a lot.